Professor Smith, welcome to Constituting America's Constitutional Chats. We're going to ask you to give a few opening comments about our topic today, and then we'll go to some questions.
All right, well, thank you, Kathy, and thank you all of our panelists. It's good to see everybody again, and thank you folks for tuning in. So today we're going to talk a bit about the First Amendment and social media and really focus on a particular issue there pertaining to what we might call government coercion of private entities. Let's start at the top. I think most people recognize, and if you don't, you now will, that the First Amendment protects us, protects our speech from government censorship. But it doesn't normally protect it from private censorship. You don't have a right to be able to say what you want in a meeting hall, in a private meeting. You don't have a constitutional right to demand that a newspaper publish your views or something like that. So it protects us from government censorship, but not private censorship. In recent years, there's been a lot of talk and some litigation and laws passed over the question of whether or not states can require private social media companies. These would be platforms anywhere from huge platforms like Google and Twitter down to lesser, somewhat smaller ones like Reddit, and even down to small other platforms and local newspapers on the web and things like that. Can government require them to carry certain views? Can we take the approach that they can censor people on those sites, say, we don't want those views, you're kicked off, or must they carry them? And there's a lot of argument. Are they more like newspapers that clearly don't have to carry your viewpoint just because you want them to? Or are they more like telephone companies where if you're talking on the phone, the idea that AT&T could say, oh, we don't like what you're saying on the phone, you don't get service anymore, I think would be very foreign to us. But today, and those are interesting questions, but today we're going to focus a little bit more on a slightly different issue, which is what happens when the government uses private entities to engage in censorship that the government could not itself engage in. Let me give you an example from outside the First Amendment arena. The Fourth Amendment to the Constitution prohibits government from unreasonable searches and seizures. You have to get a warrant and so on. Well, the government couldn't go to, say, a private detective and say to him, hey, will you go, we can't get a warrant to search this guy's house, but we think there's some really good stuff in there. Why don't you go break into his house? We'll promise we won't prosecute you, and you see what evidence you can find and give to us. That would still be generally a government search, even though they'd be using a private party to do the work. Well, some of the same occurs in the First Amendment sphere. For example, way back in the 1960s, the case got to the Supreme Court called Bantam Books v. Sullivan. And in this case, a committee of the state of Massachusetts, a governmental unit, sent a note to booksellers saying, hey, we think a lot of these books should be pulled off your shelf. We think they're pornographic and violate our laws on pornography. And so we think it would be a really good idea if you pulled them off your shelves. And that would, quote, prevent us from having to recommend to the Attorney General that he commence prosecution of you. The Supreme Court held that that was essentially government censorship of the books, to threaten the book dealers, hardly at all veiled threat, saying, if you don't do this, we're going to voluntarily, we'll try to get you caught up in legal problems, was problematic. Well, this is where we come to now the cases of censorship on social media today. Many people, as I noted, are upset that they feel like social media platforms don't carry their views or censor certain views, and that's up in the air. But what happens if the government gets involved? Now, clearly, the government has a right to speak. Let's suppose a newspaper or a social media platform puts up something, carries a column or a speaker, and the government thinks this is wrong, this is not correct. I think government officials have a right to contact them and say, we think that what you've put up there is wrong. Take an easy example. I might say, this violates national secrets and maybe puts our agency personnel overseas at risk of being murdered, right? The government has a right to do that. The government has a right to say, you've got the story wrong, look at our side of the story. But can they go much further than that? Can they kind of coerce or persuade people? And this is the issue. The case is called Missouri v. Biden, and it was brought by the states of Missouri and Louisiana and a number of private individuals, including Jay Bhattacharya, who's a award-winning doctor who had a number of views that were contrary to the popular, or at least the official narrative of COVID at the time. And they alleged that their views were censored at the behest of the government, censored by private companies, but at the behest of the federal government. Some of the things that were called up that the platforms were censoring included posts about the origins of COVID-19 and the so-called lab leak theory. Did it originate in a lab in China? A theory originally discarded by most people by the official line, but now viewed as, well, quite probably that's the case. Criticism of government lockdown policy, arguments about vaccine side effects, but it also went to other things, such as arguments about election fraud in the 2020 election, arguments about the security of vote by mail, arguments about the Hunter Biden laptop story, but it even went to things such as simply post about the economy that were not favorable to the Biden administration, parody accounts making fun essentially of Jill Biden, the First Lady, and other members of the Biden family, and a host of things like that. And what was happening was that government officials from a host of government agencies were consistently getting in touch with these social media platforms and saying things like, you must take this down immediately, report back to us as to what you're doing. They were, the FBI, the White House, the Surgeon General were demanding certain policies be enforced. And when the social media companies originally often pushed back and said, well, that doesn't violate our policy, we're going to stick with it, the government people got quite nasty and threatening. It would take me a long time to run through all the examples, but they run for over 100 pages in the opinion of the district court in Missouri v. Biden, of quite serious stuff. Quotes from the White House such as, take this post down ASAP, or please remove this account immediately. And then the Twitter removed the account. This issue needs to be resolved immediately. We plan to hold you accountable, and things like this. So the question is, did this cross the line? The district court held that it did cross the line and issued a broad injunction against a number of government agencies contacting social media platforms at all. The Fifth Circuit, the case was appealed, and it went to the United States Court of Appeals for the Fifth Circuit. And the media reporting on this was very bad, because much of the media reporting was talking about how, the Fifth Circuit dramatically narrowed the injunction and so on. And it did. It held that the injunction had used language that was a little bit too broad, kind of said, you're prohibited from even contacting these people and so on. But it upheld the fundamental finding of the district court, which was that the government's pressure on the companies had crossed the line from just pointing things out, some encouragement, to pressuring them, threatening them, and using government coercion to get them to censor speech that the government itself could not censor. This, to me, is one of the leading threats to the First Amendment, to free speech in our society. If government can go about and essentially threaten people and say, you either take this down or we'll get you. We have regulatory power over you. And so that's the case. And the issue, I think it will very likely be taken up by the Supreme Court. We will have to see. But I hope that adequately frames things and explains a fairly complicated constitutional issue, and we can get into questions.
Well, thank you, Brad. That was a great overview. And I love your analogy with the Fourth Amendment. That really puts the issue in perspective. I know we've got a lot of questions. So Janine, I'm going to toss it to you.
Thank you. Yeah, no, I'm not muted. Thank you. Thank you so much, Mr. Brad Smith. So what do we do about this new sort of way of thinking in our country today, which is, I don't really care if this is against the First Amendment. It benefits my party.
Well, that's always been what the First Amendment is about, was the idea that people always think, well, this benefits my side. And, both sides can be very guilty.
Let me rephrase that. Sorry, I don't think I made that clear. Not when they use it for good, when they go against it. So let's just say, I know the First Amendment prevents me from telling social media what to post. The First Amendment says I shouldn't intrude, but I'm going to intrude anyway and go against the First Amendment because it benefits my party. This seems to be the thinking these days. What do we do about that?
Right. I think it is the thing. And I think all we can do is point out first that the First Amendment prohibits that. I mean, if you want to say, well, I'm just going to ignore the First Amendment, fine, but hopefully we will have judges who will continue to enforce the First Amendment. But it shows a danger in society. If society loses its regard for free speech, the judges will eventually follow because they will come out of that society. So one of the things I think we need to point out is that free speech benefits everybody. At some point, all of us are going to be on the receiving end of a party in power that says, I think your speech is dangerous and damaging and it needs to be limited. The other thing is we need to remember some of the fundamental principles from, for example, John Stuart Mill, who often talked about, or in On Liberty talks about the importance of free speech and how, if we can't speak freely, we can't really test ideas to know if they're true or not. We lose sight of our own ability to defend our beliefs. And you think about all the things that have been cited as disinformation in recent years that turned out ultimately to be true, or at least people now commonly do think, yeah, that's a pretty good position. One is the lab leak theory I mentioned earlier. That was a particular item of censorship. Another is the Hunter Biden laptop story. Remember, that was initially a bunch of national security experts got together and said, oh, this is Russian disinformation. Now everybody knows it was not Russian disinformation. What you do with its contents is a whole nother issue. But so we have lots and lots of cases where we see that something that was sort of the official view was challenged, and eventually that changed. And we just need to point this out to people, that it's important. If we're going to make progress as a society, we can't censor ideas because it could be that those ideas turn out to be correct.
Well, I think what's going hand in hand here is a censoring of the press itself. And if the press is censored, then say social media is censored. Okay, I can try to explain that because social media is press. But like the lab leak theory, what I'm finding is people are only going to one source of news that is their echo chamber. And I could be having a conversation with somebody where they don't even have the knowledge. They don't even know anything about it because there's a certain genre of press that has not even talked about it, zero coverage. So in the beginning, you could have gone and said, oh, well, the whole computer laptop thing. And they would say, what laptop thing? So what do we do as a society when we're being force fed in these divisions here, certain elements of information that we're not even privy to what's going on? I think this is one of the reasons that freedom of the press is so important. But I think as a society, what we need to start doing is we're gonna really use that freedom of press to read both sides of the press so that we can really understand what's going on, because there just seems to be completely, that people are talking like this because they watch this or they watch that, and they're not even understanding what anybody's talking about. Someone says, oh, I couldn't believe so-and-so said that. How could they possibly believe that, knowing what's out there? And I said, it's because they don't know. They're not getting the information. So it's not just a suppression of the press from outside of someplace else, like the government, right? It's a suppression of the press within the press itself. I am going to create the mind here, and I'm going to force feed them what I want them to know and not to know anything else. What do we do about that?
Yeah, you're quite right, Janine. I mean, I run into that all the time, even with very, knowledgeable people who follow public affairs, other faculty and so on at the law school. I'll mention something. I would just be like, what? I've never heard of that. They have no idea of those particular facts or something like that. And I'm sure that happens sometimes back in the other direction. The First Amendment can't do a whole lot about that affirmatively. The government can't force you to listen to views you don't want to hear. But obviously we can stop the censorship, both public and private. And we just need, again, to convince people, look, you'll be a happier, better person if you get out of your silo and listen to a lot of views. There's actually a lot of studies that show that if you just keep listening to the same folks, your views keep getting more and more extreme, and moreover, you become less happy because you start to view other people as being threats to you. And we need to stop coddling certain ideas, and we need to push back against ideas that, for example, speech can be violence, or that speech can threaten you in some way. We need to be more saying, no, look, you need to be able to deal with opposing opinions. I sometimes say to my law students, I point out to them, if you're afraid that hearing some ideas is going to be bad, think about it when you're representing somebody in court, and maybe they're going to jail, depends on you, or they're keeping their fortune or employing, protecting their company that employs thousands of people. And you can't just say to the judge, Your Honor, I feel threatened by opposing counsel's speech. You have to listen to it and respond to it, and it makes you a better lawyer. I think also outside of that, it makes us better people to hear other views and to try to understand what's going on. Most Americans are actually, pretty decent people, and there's a lot more that we have in common than that separates us. But if you don't hear other views, that hurts. So I don't know quite how you do that. I think this kind of programming helps. I think talking to people about the value of free speech helps. But again, at the most basic level, we can say, look, the First Amendment definitely protects this stuff, and you can't try to censor other people's speech just because you don't like it, or you think it's threatening, or you think it's wrong.
Yeah, knowledge is power. There is also something I was thinking about the other day, which is why in our country today, which is stunning to me because we've come from so many different places around the world. Why is the thought today, you have to believe the way I believe? It's like, you have to believe this. And what if someone wants to say, well, I don't want to believe that? And they go, well, you're this, you're that, you're this, you're that. But I mean, where is this dynamic happening? And I think it's very dangerous that that people think you have to believe the way I believe, and you have to accept this, and that this is the way I believe. And that's just, there's no freedom in that. But that seems to be the mentality today from a certain sects, sectors. By that I mean, you have to believe the way I believe, and if you don't believe the way I believe, there's something wrong with you.
Yeah, we definitely have that. You have an environment in which, for example, it's not only do I have to sort of accept that you think something, but I have to agree with it or celebrate it in some way. And again, I think that's just part of this dangerous outgrowth. And to be honest, I don't really know the answer to that. I think it goes way back into the grade schools where kids have been taught for many years that speech can be harmful, and sometimes we've lost track of what is fact and what is opinion. You have these so-called fact checkers in the media who are constantly coming out and saying, well, this is literally true, and then they put all these qualifications around and they rate it like false. We have to get around that idea. Opinions are not true or false. They are opinions. They can be respected or not. People have earned them or not. And we have to be open to hearing those opinions and recognize that simply because you disagree doesn't mean that something is false. At the same time, some things are false. I don't know. At some point, we have to learn the difference.
Yeah, I think I'm going to toss to Tova now. I just believe that it's just stunning to me, really, what's happening in the country is that there isn't this sort of acceptance of different genres of, just the way we think there are different genres of religion. I think we're pretty good about that. Okay, you have your different genre of religion. Well, religions have certain beliefs. So you're telling me I can't have the beliefs within my own religion because it might not correlate with what you think is right. It's just really, I think that the more civil civic conversations we can have, the more we can really see both sides of the issues. We'll really be able to reason and then have more empathy for the other point of view. But right now, it's just this: you're wrong and I'm right. Which Tova, who I'm tossing to right now, did a great. How many years ago was that, Tova? We filmed Tova on beanbag chairs. I think she was in 8th grade, speaking like she was right out of college about everyone doesn't have to be 100%. Just because it doesn't mean what you say, Tova. They don't have to be 100% right. Anyway, Tova has already spoken to this brilliantly as an 8th grader, so I'll toss to Tova. Thank you so much. Thank you, Mr. Smith. Thanks so much.
Thanks, Janine. So one question I had was specifically regarding social media. I think it's a really interesting situation because speech is not limited to people within the US, which I think, it's interesting. You're in this global community where there's people from all other countries publishing things and you're reading them in the US. So I was curious, how does this idea that social media is a community that transcends national boundaries, how does that affect the enforcement of the First Amendment? For instance, what if misinformation is coming from another country? Can the government, compel a social media site to take it down? And also just like more generally in a globalized, connected community, how does that change our understanding and enforcement of freedom of speech?
That's a great question. I'm not sure that from a First Amendment from a First Amendment standpoint, it either can or should really change our approach. I mean, people have a right to hear views, and you have a right to hear views from, folks overseas. I think that's different, for example, from saying voting. Voting, we as American citizens are deciding who we want to govern us, to elect, to represent us. But that's very different from saying somebody, wants to try to influence how we think. I always laugh that we're always told, it's the Chinese, it's the Russians. Well, maybe it's a British outfit that says, hey, this would be really good policy for you guys overseas. Maybe it's the Chilean American Chamber of Commerce saying, we think a free trade pact between Chile and the United States would be really good for both countries. We always use these sort of horrific examples rather than the sort of good examples. And we as listeners have a right to hear, I think, as well as the right to speak ourselves. So, there are obvious exceptions where things are truly threats to national security or life-saving threats, life-threatening, issues. And these have always been exceptions to the First Amendment going way back. They tend to be very narrow exceptions, and I think that's appropriate. Yeah, I mean, I think you're right. It adds a somewhat different dimension to it, but ultimately we're still talking about ideas, our ideas and exposure to ideas so bad that we would want to limit them. And I think the answer to that really should be no. It may be that people around the world have good things that we ought to hear and might want to hear.
Right, but what I'm curious about is what if it is like a concerted deceptive effort from a foreign government? You could insert whatever foreign government you want, but it is a fact that there are foreign governments that will try to do campaigns of misinformation, passing themselves off as American actors, et cetera, attempting to influence opinion. At what point could speech be considered a national security threat? For instance, let's say the Russian government tries to spread misinformation about an attack in the US, that something has happened, and tries to incite hatred against a certain group, and is actively deceiving. Is there a difference in law between active coordinated deception versus like a sincerely held opinion?
Well, there's a couple of things here. Let me start by noting, for example, like when people talk about Russian interference, this was big after like the 2016 election, and the Russians were trying to interfere with our election. And I always kind of would laugh that, of course they were. What kind of geopolitical rival would they be if they didn't try to interfere with our elections? They've tried to interfere with our elections for decades, way back in the 70s and the 60s and the 50s. There's documented efforts. And our response to that was not to say, we'd better sacrifice our own First Amendment rights. Our response to that was to recognize that A, speech will expose that, and B, the good judgment of the American people will defend us against that. Our response cannot be fear and preemptively giving up our own constitutional rights. Now, when you talk about the other point you raised, though, that I think is a very good point is, well, what about outright deception? There is room to regulate deception, law, or fraud, and so on. And for example, where you have this use of deep fakes would be a classic example where you can take a person's face, you could make it look like I'm Barack Obama saying these things today, or Chuck Schumer, or Mitch McConnell, or whomever you want. To me, that's kind of fraud, and I think can be governed under traditional notions of fraud in the common law, that you can't go out and intentionally deceive someone in that way. Now, that doesn't mean I can't engage in hyperbole. It doesn't mean I can't engage in speech that people don't like, but I do think that's a narrowing construct. And then again, as we've talked about, there are cases, when you get into wartime and so on, where certain things can be viewed as true threats to national security. But most of what we're talking about here does not fall within those kinds of exceptions, which would probably need a whole nother show for us to work through those. What we're really talking about here, like in Missouri versus Biden, again, just accounts that are critical of the Biden economy, accounts that may be wrong, may be right. I don't even know exactly what they said, but were critical of lockdown policies and things like that. Parody accounts of Joe Biden. Those are not the kind of things that we can be worried about. And the government has no business pressuring social media platforms to censor those or take those down or de-emphasize them in their algorithms.
Okay, great. Thank you. And so I was curious, going back to what you were saying earlier, I know these are sort of hypotheticals, but I mean, they're fun to discuss. So what if the government could prove that someone specifically knew what they were saying is false and is like intending to deceive people? would that allow them to have more sway, to imply that something is taken down, or legally it doesn't matter if someone is intentionally saying something false versus a truly held belief? Is there a differentiation in law?
Yeah, this is a controversial issue. There's a key case from a few years ago called United States v. Alvarez, where Alvarez was going around telling all kinds of lies about himself, including that he had won the Medal of Honor. And there is a federal statute that says you can't say you won the Medal of Honor if you didn't. And that's something that's demonstrably provable as fact, and it's within the knowledge of the person. He knows if he won the Congressional Medal of Honor or not. And yet the Supreme Court still upheld his right, saying he couldn't be criminally punished for making that statement. So that's where we kind of are. It's a controversial point, but the Supreme Court's view was, again, if you don't protect these things at the extreme edges of speech, you can't be sure that people will protect it. You will start cutting away at speech more and more and more in different areas. I still think there is room, as I say, for certain types of speech that you can say harm somebody. So one argument would be, well, when he said he won the Congressional Medal of Honor, part of the question was, were people harmed? Were actual Medal of Honor winners harmed by that? Was the public harmed? And that might be different from something, again, where I'm making it appear that the president is saying I won the Congressional Medal of Honor through a deep fake, or something where I specifically am lying about someone else that would be punishable under traditional defamation laws and so on. So that, again, you've hit on two really great questions, sort of national security and this question of just knowing intentional lies. I think the court's been right to err broadly in protecting speech, but there is room under traditional common law notions, again, like claims of defamation, false advertising, to regulate certain types of those examples.
Thank you. And then this is a big question that I think is kind of complicated, but I'm curious about the role of humor and satire in what can be taken down. So for instance, like inciting violence, I think broadly, if there was like a specific threat of inciting violence, a lot of people would maybe agree that that is something that could be a candidate for being taken down. However, I think now with the language of the internet, it's often a very ironic place, a lot of jokes, a lot of memes, like it's often clothed in a lot of layers of irony. So how do you differentiate? And people, of course, if they're caught, might say, oh, it was a joke. I would never do that, obviously. So legally, how do you differentiate between a joke or something that's ironic versus an actual threat that needs to be dealt with?
Another great question. It goes back to, I think, your earlier questions, which is, again, why we want broad protection is how do you draw the line on these things? People, if you want to have fun, you can look up on YouTube old commercials involving a guy named Joe Isuzu, who would advertise for Isuzu cars by making the most outlandish, preposterous lies that everybody could tell were lies. And, that's the kind of problem. If you say it's illegal to tell lies, you have to start sorting out parody accounts, people who are just having fun, people who are telling innocent lies. It becomes a very difficult scenario here to get into. So parody has always been difficult for the courts, but I think, again, if you get in a close case, I'd rather see the courts err in favor of free speech. And I think that goes to promoting one of the ideas that were in Janine's questions earlier, that we need to get over this idea that we're always threatened by speech. Parody account, you may not like it, but it's really not going to harm you.
Okay, thank you for being on. I'll now pass to Jewel and Jordan.
Hello, the show has been great. I've learned a bunch. I've followed, current events, pretty well, but I didn't realize some of what you said in that Missouri case and some of the other things that you've said. I think it's important for us to hear. There's a big question I'll start with, which maybe it's just an opinion, and then you could respond to it. So our First Amendment, we've talked about before how important it is, and interesting that it's first, rooted in this idea of the word and the logos coming from Western civilizations, philosophy, and Christianity. Our founding fathers protected political adversaries overall. Of course, there's examples where that didn't happen, but overall, there was some pretty horrible political cartoons. Absolutely absurd things that when you see them, you're surprised that they were published. And these things were generally protected. But there's a distinction that I believe in the freedom of speech that we seem to have lost somewhat, is that political rhetoric and political misinformation that we've called it was not, the founding fathers protected that in the First Amendment, but they did not protect counties and states blocking obscene material, and I believe today that they would block videos of violence, killing videos that are on the internet. There, almost every place you could look at down to a local level had very strong obscenity laws, and it was not protected under any form of freedom of speech, especially pre 14th Amendment, because that was before the Bill of Rights was expected to be followed at every state level and interpreted that way. So there is a distinction and a belief in, the American people. The founding fathers also said that our government was created to rule a virtuous people, and that's on us, of course, to develop that. But when we have this freedom of speech discussion, we shouldn't be lost sight of that they protected political speech, horrible, absurd, even sometimes violent cartoons, but they did not protect obscenity in any way or explicit content. There's strong laws against it.
Yeah, so there's a lot there, and I hope I remember it all. Let's start with a key point that you made, which some people may not be aware of. The First Amendment, of course, just says Congress shall make no law, and it was generally held originally that it applied only against the federal government. And as you mentioned, the 14th Amendment, which was passed after the Civil War, held that essentially the rights and privileges of U.S. citizens had to apply to people in the states. So it did what's called incorporate it into the against the states, the First Amendment. So now states also cannot infringe on those free speech rights. Now, what does that allow both the states and potentially the federal government yet to do? Well, there are narrow exceptions. For example, Tova in her last question raised, I didn't really quite respond to it. She raised, what if something's an incitement to violence? That is still not protected. Obscenity is still not protected. But in both cases, the Supreme Court has defined those quite narrowly. Incitement to violence has to mean, you're going to lead to imminent violence. It's very, very tough to win those prosecutions. Likewise, the definition of obscenity has gotten quite narrowed down. I think, the point you make is a good one. The court's view, again, has been that if you don't protect some of these forms of speech that I think most of us would agree are sort of worthless, if you don't protect them vigorously, then again, you're going to start backsliding on the speech you do more care about. And you create doctrine that leads people to say, well, this political speech is harmful too. This is more harmful than some pornographic magazine. This could, upend our democracy and we'll end up with some dictatorship or something. That sounds worse than some people looking at pornography. So, if you don't protect the sort of speech that you all agree isn't really exactly what we necessarily want, most of us, it may be a bad idea. You protect the worthless stuff in order to make sure that you're protecting the core. That's the route that the Supreme Court has taken, going back many generations. At this point, it would be difficult to change, and I think there is much to be said for it. Again, there are exceptions like incitement to violence. There are exceptions for what's called fighting words. It's an exception like that, but they've been very narrowly construed, and probably on balance, I think that's been for the good.
Yeah, I think it would be useful for those of us constitutionally minded to think about that and think about our founders' perspective on it, and how we have left them somewhat on this topic as it's developed in the courts. I think Jordan's got a good question next.
So I want to get back to social media a little bit, and I've heard of what I think it's section 230, and my understanding is that social media is covered so that they're not responsible for content on their pages as a publisher would be. So they're not viewed as a publisher, but if they are a public company, aren't they responsible for upholding their bylaws to the letter and not favoring which posts they censor or not, since they have public stock?
Yeah, so social media, of course, is a tough issue, and I've focused on the Missouri versus Biden case. There are a couple other cases that are going to go to this before the Supreme Court, relating to efforts by the states of Texas and Florida to regulate the content on social media, mainly by telling them that you can't discriminate against certain posts and viewpoints based on the viewpoint. There is what's called a Section 230 of the what was called the Communications Decency Act, passed back in the 1990s. And what Section 230 did initially was it held, I think there's two key parts to it. The key part that everybody agrees on is it said, look, social media companies are not liable for things that they do not post themselves on their platform. In other words, let's take a traditional newspaper. If a traditional newspaper, if you bought an ad in the newspaper and in that ad you libeled somebody, okay, the newspaper could be held responsible for publishing your libel. Newspapers, are fixed. They can only take so many ads. They can only run so many columns and that sort of thing, and they have to edit through everything. Whereas social media, one of the big things is the space is almost limitless, if not limitless, to publish as much stuff as people want. And social media outfits could not begin to police all the posts that appear on their site. So if you want social media to really be something that's very democratic, where anybody can get on, reach a much larger audience than you used to be able to do, you want to say you can't be liable for anything somebody says, because they can't begin to police everything that everybody's saying and look to say, are you saying something libelous in that respect? So Section 230 protects them from that. It says you're not liable for libel or other offenses by people who just post on your site. If you post yourself, you are, but you're not liable for what other people post on your site if you make it available. The next section of Section 230 is the more controversial one, which provides for certain exceptions. Now, in my view, my understanding, my reading of the law, which is not the unanimous one, is that this section says platforms will not be considered publishers if they censor, if they take down material, if they say, here's what's good, here's what's bad, and do it for a series of reasons. One was indecency, pornography and so on. Another was national security threats, a couple other items like that. And to me, that was just saying you can edit out those things without becoming a publisher and thus being liable for everything on your site. That's how I understand it. That's not how all do. So others view it as a more blanket, again, second blanket privilege to them. So I kind of agree with what I think is the thrust of your argument, which is if the platforms are going to say, look, we're platforms, we're not liable for what's put on our site, I think it's very, I'm not sure they can get away with just saying, and we're absolutely free to censor whatever we want and still not become publishers. We're publishers for some things, but not for others. When somebody goes after them and says, well, you have to publish all comers, they say, oh, no, we're not a publisher. We're just a platform. When you come after them for libel, they say, oh, we're not a platform. We're a publisher. I don't think that can work long term. And so, again, that's a good question. It's one I think the Supreme Court is going to have to be sorting out this fall.
Thank you very much for wow. You really know your laws. Your wealth of knowledge is quite wonderful.
We're gonna get to. I think we'll go to
From
some
being
other.
old, Jordan. It comes from getting old.
Well, thank you, Brad. This has been really fascinating. And we have got a lot of audience questions lined up here. But first, I want to give a quick shout out to radio station KKVV in Las Vegas that airs our podcast Monday evenings at 6 p.m. Pacific. They are found at 1060 a.m. on the radio dial. And we want to thank all of KKVV's listeners and thank KKVV for airing these podcasts. We also want to give a quick shout out to the students who are listening with us today. We have quite a few students in the audience. And let's see, I thought I had the list right here. And I apologize. Here we go. Cami Wainhouse has a homeschool student. Lizette Flores, Grace and Faith Academy has students watching. Alan Amdahl has 20 students with Albany Senior High. Welcome, Albany Senior High. Sherry Stiegel has homeschool students watching, and Hope Mucklow has homeschool students watching. So welcome to all the students. And if you're a student or a teacher with students watching, please let us know in the Q&A. If we didn't give you a shout out, we'd love to recognize you. Now, going to some of our audience questions, Beth Ann Smith asked, how do you perceive the First Amendment will be challenged as artificial intelligence becomes more popular?
I've heard some people arguing that, artificial intelligence is a whole new thing that we're just going to have to, somehow we're going to have to police it. There can be so many false statements and so on. I think that's the wrong way to go. I don't think it really changes anything in terms of, our ability to want to hear things, the ability of people to gain information. like I say, if you're using artificial intelligence to pretend to be someone that you're not, in the way of deep fakes, that may be there may be some room for regulation there. Just as, again, it's fraud. I'm making it look like I'm Donald Trump or whomever, Joe Biden, and I'm not, and I make it look like I'm saying things as that person. That's just kind of fraud. But generally speaking, I don't think that AI changes or really challenges our core First Amendment doctrines. And those are based, again, around the idea that people have a right to hear things, and we give broad protection to speech, and we have some exceptions, but those are narrowly construed.
Well, thank you. And Tom Garrett asked, to flip Tova's excellent question on his head, given efforts by some foreign governments such as Canada, the EU, UK, etc., to regulate online speech, how do you assess the potential danger of such regulations to nonetheless negatively impact American speech rights through a sort of backdoor by forcing American social media companies to abide by regulations originating from governments that need not abide by our First Amendment?
It's a tricky question to follow all the way through, but I think what I'm hearing here is, what is the effect if we start worrying about foreign interference here, but other countries are censoring what goes on there? I think there are a couple of things. One is, I think we need to make sure that our tech industry remains competitive, sort of at the forefront of things. So we sort of remain dominant with our more open values, and hopefully, we can't do much but encourage then our private companies to push back against some of these efforts of censorship. They probably won't be successful against totalitarian regimes like China, but they might have some success against, we see a lot of, like, the European democracies trying to limit and threaten speech more. And so I think it'd be, that's worth noting. I think, again, to me, an important thing for us to remember is that, we're talking about our speech rights. So if we say, oh, well, we can't let foreigners have any interference in American politics, first, they might have things that we want to hear at many times, but also think of how that starts to affect in an era of international cooperation and international corporations. Any large corporation is going to have shareholders probably from overseas, and so you could start to have this become a backdoor way of censoring what Americans can say. You take a company like Jeep. Jeep is the quintessential American company, and yet it's foreign owned. So if you're going to start saying, well, we can't let Jeep speak, and therefore there's nobody to speak out on behalf of Jeep shareholders, pensioners who are largely American citizens, Jeep's employees who are largely American citizens, that's very bad for the interest of American citizens. So I kind of go back to that Cold War analogy. We didn't limit our own speech rights, and to the extent there were efforts to do so in what's called the McCarthy era and the blacklist and so on, those are generally not fondly remembered now. Those were viewed as that was a mistake. We should have been willing to tolerate some of that speech, recognize that maybe it's not quite as threatening as we first think if we just step back for a bit.
Well, thank you for that. And then Michelle asks, is there any difference between a political campaign of a non-elected candidate pressuring social media to take down a post as opposed to the government pressuring social media to take down a post?
Sure. And this goes to the real heart again, or at least one of the questions that would flow naturally from Missouri v. Biden, the case there, which is what constitutes pressure. Again, private companies generally have a right to speak or not to speak, to censor people if they're so inclined. In this case, if you're just a candidate for office, it's pretty hard to argue that you have the ability, the government power, to harm somebody. You might have a lot of private power. You might be able to say, I'm going to pull my advertising off your webpage or something. And by the way, I personally tend to think that's not a good practice, because I think part of the whole spirit of the First Amendment, again, is that you're open to ideas. You combat them just by expressing your own ideas. Nonetheless, as a First Amendment matter, that's probably okay. What we're looking at when we're talking about government coercion is government people, the government bodies. The Fifth Circuit, note, I'm trying to look at the standard here real briefly. They said the government has to exercise coercive power or provide what it called significant encouragement. That would be sort of, we're going to make you an offer you can't refuse type thing, or it would have to engage in what it called meaningful control rather than mere passive regulation. In other words, the fact that the government, like say, regulates liquor stores doesn't mean it's interfering with their speech. But if they start calling up the liquor store owner and saying, hey, we see you gave money to this candidate, or we see you were saying these kinds of things on your blog, the liquor department may want to come around and inspect your place. That's not passive regulation anymore. That's the kind of government threat. So I think that's somewhere in there. It's a hard line to draw, but I think it's one that has to be drawn. And I think the Fifth Circuit and the district court both got it correct.
Thank you. And then Sandy Thatcher has an interesting observation. He says, Section 512 of the Copyright Act offers internet service providers immunity for third-party postings, but allows for copyright holders to file takedown notices. Do you have any comments on that?
I don't really. I'm not familiar with that, I have to say, which leaves me feeling somewhat chagrined. It seems like it would be a fairly basic thing to know. But, I think you're in a position where if you have a copyright and somebody is violating it, it makes sense that you can file that, put the company on notice, and they can take it down. And again, to my mind, that's what part of the Section 230 that Jorn brought up a while ago was about. It was to say to companies, yeah, that's the kind of thing you can take down, and it will not make you a publisher subject to defamation claims and libel claims and so on. But it was not intended as a blanket immunity saying you could start censoring views you don't like and so on, and still then claim that you're not a publisher.
Okay, thank you. And then Andrew K. asks, how can we expect society to respect free speech when such a large plurality or majority have never been educated in either the Constitution and its amendments, nor in the thinking that went behind those precepts?
Yeah, I feel like some of these questions raise good points that are just above my pay grade here. I think, Andrew, yeah, you're onto something. If we don't pay attention to the Constitution, we don't teach it, we don't learn it, it's going to be tough for people, to abide by it. I mean, I'm glad we have programs like this. Somebody the other day, an old friend of mine, noted the prevalence of an opinion poll showing that I think it was like 48% of college students thought it was okay to shout down speakers and so on. And she says, boy, we didn't teach these students our values. And I responded actually saying, and, she and I are both on the same side. We're both pro-free speech people. But I said, actually, unfortunately, we did. I mean, maybe not you and I, but speech codes on college campuses have been a fixture for 25 years, and the courts routinely strike them down, but colleges keep throwing them up. We have in the high schools and the elementary schools teaching people that speech is violence and speech can threaten you, and people shouldn't be allowed to say certain things. We have a lot of elected officials who really think there is something called hate speech, some definable category that can be banned by the government. So, yeah, it's going to be a long-term battle in which those of us who believe in free speech have to kind of start aggressively pushing back, but also educating folks as to the value of free speech, even when it seems like things that we don't, things with very little value, like false speech or obscenities or things like that, that we need to kind of take that John Stuart Mill approach and point out that ultimately, the danger of giving government the power to censor this stuff is worse than allowing some of these activities to go on. We shouldn't discourage them as part of our obligations to civil society. We might want to make sure that we ourselves, watch our public speech, that we don't go to pornographic websites or whatever. But maybe that's not the role for the government to do that.
Well, and thank you for being with us to help educate us on free speech. And I know I've learned a lot today. I'm going to jump back to Tova and then to Jewel and Jorn for just a couple of closing questions.
Yeah, well, I was just curious. I kind of wanted to play a little devil's advocate to what you were saying earlier about words not really having harm, because I do think that there is an argument that, words are the very thing that can lead to harm. Like any physical act of violence that's ever happened has often started with words. So I don't know, what would you say to people who would say that, words, while not being necessarily a violent act in itself, can lead to harm and to physical violence, especially when you're in a social media community where a lot of people are saying the same violent rhetoric, and there's sort of a tendency for it to get more and more extreme when you are in that sort of echo chamber. especially when it is paired with disinformation or maybe something that could be incitement. So I'm curious what your thoughts are to that sort of argument.
Yeah, well, there's a couple of things. First, again, there are exceptions for fighting words for incitement to riot. So there are some narrow exceptions that would cover that. And of course, the underlying acts of actual physical violence are prohibited. But I think generally we can't get caught up in this idea of speech as harmful in and of itself. I thought you were going to say how words themselves do hurt. And of course, that's very true. Words can often hurt and they stick with you a long time. But the law has long recognized that it's not a legally cognizable harm. That's the sort of legal phrase. And by the way, I'll give you another example of that. If I go out and start a coffee shop next to the coffee shop that already exists, it probably hurts their business. But we've long said that's not a legally cognizable harm. They can't sue me for it. What we've recognized is that there's just sometimes, absent somebody actually physically harming you or stealing your money or something, the cost to society is just too high. Everybody could be suing everybody over sort of everything. And how do you draw a line if you don't have a very narrow exception as to when that speech has gotten too excitable? What if I just start spewing out vituperation? Well, people who disagree with me are idiots, something like that. And somebody else derives from that we should physically silence them. So again, I think the concern's valid, but I don't think we should let it overtake our common sense, that we should keep some perspective and recognize this is not usually the case. You know what? It's not usually that bad. If you have a disagreement with somebody and you walk away disgruntled, that's kind of part of life. And that's part of that exchange of ideas and making sure that ideas can get out there.
Right. And I'm curious, with our sort of increased awareness of mental health as something that, people deal with, has that changed any sort of legal standard where, if someone's like purposefully saying something to harm someone's mental health, to incite them to harm themselves, et cetera, does that,
We've
recognize
Sure.
it?
Sure. We've long had a common law tort of what's called intentional infliction of emotional distress. And that is one way in which words could cross the line. If I were to call up somebody especially if I knew they're in a tough mental situation right then, and lie to them, say something like, "Oh, your daughter was just hit by a car," or even something like that, not even something mean to them, that could be viewed as intentionally inflicting emotional distress on a person. That's a common law tort. So there are these various common law torts that have always been recognized as exceptions to the idea that Congress shall pass no law prohibiting freedom of speech. But I think I keep going back to that point. So I think you've raised good points. I think you've raised a lot of the tough cases on the line. But my basic idea is, yeah, they're tough cases, and we do make exceptions for that. And the trick is not to let those exceptions swallow up the rule of free speech.
Well, and that's a great way to end it. And we are right at the top of the hour. And we just want to thank you so much, Brad, for your time. It was just very enlightening episode today. And we want to thank all of our audience for being with us, and Jewel and Jorn and Tova and Janine and Lacey. And we want to invite everybody to come back next week on Tuesday at 2 p.m. Eastern. And we're going to be talking about the Second Amendment. And our current event is going to be, can a governor issue an executive order to restrict gun ownership in the state or in certain communities? So join us as we'll be discussing that. And we look forward to seeing you next week. Thank you so much.